Welcome to week 5 of the course, our final week. Joining me this week is Amna Shirazi, an immigration attorney in Atlanta, Georgia. She earned both her bachelor's degree and law degree from Georgia State University, and she also earned a master's degree in law, an LLM degree, with a focus on democratic governance from Emory Law School, where I teach. She is also on the board of the International Rescue Committee. Before we begin that conversation, though, I'd like to give you a brief recap of where we've been, as well as an introduction to the topic for this week. Last week, we looked at the benefits side of an immigration practice. In other words, the pathways to a legal status, whether that's a green card or a temporary visa. This week, we're looking at the other side of an immigration law practice, and that has to do with defending persons in immigration court. So this week, we will focus on detention, deportation, and the removal process. In prior weeks, we have looked at some of the history of immigration in the United States, and we've mentioned deportation history, but I would like to say a bit more about that. The character of that history was established in the late 19th century. Let's take a look at a slide. This is a case that we've seen before, Fong Wei Ting versus United States, and it stands for the proposition that deportation is not punishment. The significance of that, as we said earlier, is that deportation does not bring with it the constitutional rights of a criminal proceeding in the United States. And that's going to be one of our topics of conversation. Since the Immigration and Nationality Act of 1952, some 4 million persons have been deported from the United States. Each year, above 400,000 persons are deported from the United States. In fact, under President Obama's administration, more persons have been deported than any prior president. Earlier in the course, we also considered the grounds of inadmissibility. And at that time, I mentioned to you, many of those grounds of inadmissibility are also grounds for removal or grounds for deportation. Let's take a look at a chart that represents the reasons for deportation. Entry without inspection is the largest percentage, and that, as we said, is entering without going through an official customs port of entry, presenting papers, and so forth. The next largest group, however, is criminal convictions or criminal activity once you are in the United States. That has become a very, very important part of immigration defense in immigration court. Technically, these are post-entry grounds for deportation, and any number of crimes, including misdemeanors, can result in a removal proceeding. So, welcome, Amna.
Thank you for having me.
In our last lecture, we're talking about asylum. Okay. And I understand that asylum can also be a defense to deportation. So I thought maybe we would begin with that topic.
Asylum is definitely used in the immigration court proceeding as a defense from removal. However, the person needs to meet certain criteria. They need to show that they are escaping persecution based upon one of the 5 protected grounds, as you discussed earlier in your lecture. If someone can make that claim and then show that they are making that claim within 1 year of their entry to the United States, then an individual can go ahead and apply for asylum within the United States as a defensive measure. However, there are certain exceptions. If you can show that there have been changed country conditions, if you can show that you are have been referred to an immigration judge from an affirmative asylum application, you can continue to pursue your asylum application. And the ramifications of that is the standard for granting an asylum application is a lot lower. So having that 1 year, having that application be filed within 1 year gives you a greater chance of having your case be approved. If for whatever reason, through your defensive claim, it comes about that you have not met your 1 year filing deadline for either directly or through exceptions, then you're left with the other options of asking for withholding of removal or a Convention Against Torture claim, which obviously the standards for having those cases granted are far higher. So there is a direct benefit to being able to preserve your ability to apply for asylum.
So if you apply affirmatively, either upon arrival or within a year, what does that look like in terms of a process?
It can be many ways. I have had clients, aside from the refugee program, which is an entirely different program, but asylum applications are for people who have arrived to the United States. Once you've arrived, many people come in on tourist visas, or I've had clients who've come in on false passports or whatever the case is. However, once you arrive to the United States, there are those people who are fleeing persecution in real time. So when they arrive, if they're not immediately granted entry, they can, at the border, if they're being denied entry for whatever reason, they can claim persecution and go ahead and request asylum at the CBP, with the Customs and Border Patrol. However, there's another side to that. There are those people that do gain entry into the United States, whether it's through an H-1 program or a tourist visa or whatever the case is, but they're granted admissibility. They come into the United States, and then they can fill out the asylum application through the asylum office, which is based in Arlington.
There's wanted to continue speaking about asylum in particular, and let's take a look at the slide that I have here, which basically shows a Government Accounting Office report that notes the distinctions between and among immigration judges and courts in asylum outcomes. In other words, the report is from 2008, talks about different outcomes depending upon the judges. And is that your experience, that some are more hospitable to these claims than others?
It's definitely my experience, and without naming specific judges, there are certainly jurisdictions, including the Atlanta jurisdiction, that is one of the most conservative in the country. So we know that if a claim is referred from the asylum office and it is sent to the immigration judge here in Atlanta, the likelihood of that case being approved is actually very low, because the majority of our judges have among the lowest grant rates in the country. In fact, we have the judge with the lowest grant rate in the country, and two of them sitting on our 5-member court here in Atlanta. So this particular jurisdiction is not very hospitable to asylum claims. However, there are jurisdictions such as California, certainly the Northeast, various Chicago. I've had good luck in Chicago for whatever reason, and people can have various theories as to why, but there just seems to be a more liberal take on some of these cases, where a bit more deference is given to the respondent that's applying, to their credibility, and it's not as at times in this jurisdiction you feel as if you're starting from the judge doesn't believe anything you have to say, and then you just have to build it from there, whereas you feel in other jurisdictions that your client's at least getting a fair opportunity. That's my personal opinion. I'm not saying that that's any sort of institutional opinion, but that's just my personal experience.
Well, it does look like the GAO report backs that up to some extent. And speaking again about asylum, there is a perception out there held by some persons that asylum is granted too liberally and that it is abused. And again, I'd like to get your take on that view of the asylum system.
Asylum was set up, obviously, to help people who are fleeing persecution. How to prove that you are fleeing from persecution is quite difficult, because many times people leave without documents. They're entering on a false passport. How do you build that claim, and how do you show that you're a member of a specific group or fleeing persecution for political reasons when you don't have a lot of documents? So, I think one of the critiques is that people feel so much deference is given to the credibility of the respondent and their testimony. There's case law that clearly says that the immigration judge, unless they can find an adverse credibility finding, needs to give the individual the opportunity to present their claim at face value. So I guess one of the critiques is that It really comes down to the discretion of a judge. I think one of the issues is that, a judge in Chicago may be more swayed by particular arguments than a judge here in Atlanta, for example. And what it does is it makes it so that, depending on how sympathetic a judge is to a particular situation, there's a lot more leeway for them to grant. And it's not always based on documentation. It's based sometimes just on a gut feeling that this person is telling the truth based on circumstantial country condition reports. So while on one hand I disagree, I don't think asylum is liberally given out in this country at all. I think that's not true. I do see how some critiques of the process point out that there is too much power given to the discretion of the immigration judge. And then also, how can you always authenticate documents in the event that there are documents to help these stories actually either win or lose?
The preceding program is copyrighted by Emory University.